Continuation of discussion in Article 125. Number 1. What are the circumstances considered in determining the liability of officer detaining a person beyond legal period? For the purpose of determining the criminal liability of an officer detaining a person for more than the time prescribed by the revised penal code. Number 1, the means of communication, as well as number 2, the hour of arrest, and 3, other circumstances such as the time of surrender and the material possibility of the fiscal to make the investigation and file in the time. The necessary information must be taken into consideration para malaman ang kriminal na pananagutan ng isang alagad ng batas na nagkulang sa isang tao lagpas sa oras na itinakda ng Revised Penal Code. Number 1, ang pamaraan ng pakikipag-ugnayan, pati na number 2, ang oras na pahuli, at number 3, ibang mga pangyayari katulad ng oras na pagsuko at ang pisikal na posibilidad para sa piskal na makaimbestiga at makasampa ng kinakailangang reklamo ay dapat isaalang-alang. Number 2. Will the violation of Article 125 affect the legality of confinement under the process issued by a court? The failure of the arresting officer to deliver the person arrested to the judicial authority within the time specialized in Article 125 does not affect the legality of confinement of the person who is detained because of the warrant subsequently issued by a competent court when information was filed therein. Number 3, will the fiscal be liable for arbitrary detention under Article 125? If the fiscal does not file the information within the period prescribed by law and the arresting officer continues holding the prisoner beyond the prescribed period, the fiscal will not be responsible for violation of said Article 125 because he is not the one who has arrested and illegally detained the person arrested unless he has ordered or induced the arresting officer to hold and not release the prisoner after the expiration of the said period. Kung ang piskal ay hindi nagsampa ng kaso sa loob ng oras na itinakda ng batas at ang humiling alagad ng batas ay nagpapatuloy sa pagkulong ng preso lagpas sa itinakda na oras, ang piskal ay hindi mananagot sa paglabag ng Article 125 dahil sa hindi siya ang humuli at illegal na nagkulong sa taong hinuli. Pwera na lang kung inutos niya o inudyukan niya ang humuling alagad ng batas para ikulong at hindi palayain ang preso pagkatapos ng nabanggit na oras. Number 4, what is the remedy where a warrant was improperly issued? If the accused was illegally detained because he was arrested without a preliminary examination, what should have been done was to set aside the warrant of arrest and order the discharge of the accused, but without enjoining the judge from conducting preliminary investigation and afterwards properly issuing a warrant of arrest. Kung ang akusado ay illegal na kinulong dahil sa hinuli siya na walang preliminary examination, ang dapat ginawa sana ay itabi na muna ang mandato de aresto at iutos ang pagpapalaya ng akusado. Pero hindi utusan ang huwes na gumawa ng preliminary examination at pagkatapos ay magpalaba ng mandato de aresto. Number 5, what are the rights of the person detained? Right of the person detained. Number 1, he shall be informed of the cause of his detention. Dapat ipaalam sa kanya ang dahilan ng kanyang pagkakakulong. Number 2, he shall be allowed upon his request to communicate and confer to any time with his attorney or counsel. Article 1 to 5, paragraph 2. Dapat hayaan siyang base sa kanyang hiling na makipag-ugnayan at makapag-manayam sa anumang oras sa kanyang abogado. Article 1 to 5, paragraph 2. Number 6. What is the effect if the public officer or employee prevent the exercise of the right of an attorney to visit and confer with person arrested? Any public officer or employee who shall obstruct, prohibit, or otherwise prevent an attorney entitled to practice in the court of the Philippines from visiting and conferring privately with a person arrested at any hour of the day or in urgent cases of the night said visit and confers being requested by the person arrested or by another acting in his behalf shall be punished by Arresto Mayor RA 857. Kahit sinong opisyal o publiko o empleyado na humadlang, nagbabawal o di kaya ay pumigil sa abogado na may karapatang magtrabaho sa loob ng mga korte sa Pilipinas sa pagbisita at panayam sa pribado ang taong hinuli sa kahit anong oras ng araw o sa panahong kinakailangan sa gabi man o gabi. Ang nabanggit na pagbisita ay panayam ay hininga ng tao hinuli o sa pamamagitan ng ibang tao na pumagitna para sa kanya ay parusahan ng Aresto Mayor. 7. What is the reason for the previous provision of Article 1 to 5? Article 1 to 5 of the Revised Penal Code is intended to prevent any abuse resulting from confining a person without informing him of his offense and without permitting him to go on bail. Ang Article 1 to 5 ng Revised Penal Code ay sinadyang ginawa para mapigilan ang anumang pag-aabuso mula sa pagkakakulong ng isang tao na hindi ipinaalam sa kanya ang kanyang kasalanan at hindi pinahintulutan na makalabas sa pamamagitan ng piyansa. Number 8. What is the difference between Article 1 to 4 and Article 1 to 5? In arbitrary detention under Article 1 to 4, the detention is illegal from the beginning, and the arbitrary detention under Article 1 to 5, the detention is legal in the beginning start from the expiration of any of the period of time specified in Article 1 to 5 without the detained person detained having been delivered to the proper judicial authority. Sa arbitrary detention sa ilalim ng Article 1 to 4, ang pagkakulong ay illegal mula pa lamang. Sa arbitrary detention sa ilalim ng Article 1 to 5 ay illegal sa simula pero naging illegal mula nang matapos na ang alinman sa mga oras na itinakda ng Article 1 to 5 na hindi nasampahan ng kaso sa korte ang ikinulong na tao.